Today we're going to continue our lecture on agency, and we're going to look at Chapter 24, Liabilities to Principals and Agents to Third Parties, otherwise known as external agency. If you remember last lecture, we talked about internal agency. Remember from last class, the power of an agent is his or her ability to change the legal status of his or her principal. So with external agency, we're dealing with three parties: the principal, the agent, and the third party. So usually what happens is a principal has an agent to make a contract with some third party on the principal's behalf, because the principal can't be everywhere all the time. Different parties have different interests. The principal only wants to be liable for contracts he or she actually authorized his or her agent to make. The third party see things differently. He or she wants the principal to be bound on all contracts that the agent makes on behalf of the principal. Since the principal and the third party clearly have divergent interests, the law has established a middle ground. Here is the middle ground. The principal will be bound on contracts where the agent actually has either actual authority or apparent authority to do so. Again, the middle ground is that the principal will be bound on contracts where the agent has either actual authority or apparent authority to do so. In addition, the principal will be held liable if the principal ratifies an unauthorized act of either his or her agent or one who poses as his or her agent. So there are two types of authority: actual authority on this slide and apparent authority on the next slide. It's important you understand both actual and apparent authority, because this will be the basis of one of your essay questions on your final exam. Here's the definition of actual authority. Actual authority is the true authority granted to the agent by the principal. There are two types of actual authority. One type of actual authority is known as actual express authority. The second type of actual authority is known as actual implied authority. Let's talk about actual express authority first. With actual express authority, the principal describes the extent of the agent's specific powers. So, for instance, if I, as a principal, tell my agent to go down to Valencia to go buy a Mercedes for me, I have given that agent actual express authority. Actual express authority can either be oral or it can be written. So the proper name of actual express authority is known as an attorney in fact. That's the name given to agents whose authority is actually in writing. The other type of actual authority is known as actual implied authority. Here, express authority is often incomplete, and the agents may react to certain contingencies. Thus, the agents will have implied authority to do what is reasonably necessary. The test of actual implied authority is the justifiable belief of the agent to believe that he or she has authority to bind his or her principal. Let me give you an example. H is left in charge of J's store while J is out of town. J is the principal, H is the agent. J's instructions to H said nothing about the arrival of merchandise. H would have implied authority to sign a delivery receipt if he could reasonably believe that in fact he had been ordered to do so. So in this case, when H, the agent, wasn't expressly told to sign for merchandise, but just to watch the store, for instance, H would have actual implied authority to sign a delivery receipt for goods. Another type of actual implied authority is known as inherent agency power to act in emergencies. So for example, using H and J again, if a tornado breaks the windows of J's store, H would have inherent agency power to fix the windows, even if J did not give H any power to purchase anything. Remember, there are two types of actual authority: actual express authority and actual implied authority. The other type of authority is known as apparent authority. Apparent authority is created by the conduct of the principal that causes a third party reasonably to believe that another has authority to act for the principal. Here, the test is justifiable belief of the third party. Remember, with actual implied authority, the test was justifiable belief of the agent. Thus, why is there such a distinction between actual implied authority and apparent authority so important? Well, because under actual implied authority, the principal can't sue the agent because the agent had actual authority to act on his or her principal's behalf. With apparent authority, it's different. Here, the principal is now bound on a contract with a third person based on the agent or quote-unquote agent's apparent authority, and thus now the principal may sue the agent for damages based on that contract. Again, remember, with apparent authority, the test is justifiable belief of a third party by a third party created by the conduct of the principal that creates that third party to reasonably believe that some other person, whether he or she is an agent or is quote-unquote an agent, has the authority to act for the principal. As noted a few minutes before, if there's no actual authority or no apparent authority, then a principal cannot be bound on any agreement that an agent makes on his or her behalf to some third party. Thus, if there's no actual authority or no apparent authority, there is no authority. However, there is one instance when there is no authority that a principal may still be bound on a contract that someone makes on his or her behalf, and that is known as ratification. Ratification is another word for approval. Thus, ratification creates liability for unauthorized acts of an agent or somebody not appointed as an agent at all. What's the effect of ratification of a previously unauthorized act? Well, it's the same as if the act had been authorized in the first place. Ratification is based upon the intent of the principal, and ratification can be done expressly by saying I ratify, or it can be implied by the principal's acts, or it can be implied by the principal's failure to act within a reasonable time. Thus, ratification releases the agent of any liability. One other point, Ratification by the principal must be done before cancellation by the third party. The next slide is a good summary of ratification. Please take some time to review it. As noted before, the principal will be bound when the agent either has two types of authority: actual authority, which can either be actual express authority or actual implied authority, or apparent authority. Thus, if there's ever a misrepresentation by the agent to the third party, then still the principal is liable. The agent could also be liable if said misrepresentation was made with scienter. Finally, you should know about exculpatory clauses. Exculpatory clauses may, but not usually, give notice of the agent's lack of authority. Thus, exculpatory clauses are language in printed forms that are given to their salespeople. Usually, it'll say something that everything is subject to the approval of the home office. Thus, if it says that, that's an exculpatory clause. The the principal must receive and review the offer and decide to accept it. Under what's known as the imputation doctrine, has given the same effective notice. Thus, any notice given to the agent by some outside third party imputes notice to the principal if it relates to the business of the agency agreement. Thus, as remember from last chapter, one of the duties of the agent is the duty to inform his or her principal of knowledge that the agent gains in the course of his or her responsibilities. In addition, if a third party makes a payment to the agent of a debt owed to the principal, that payment discharges the third party of the debt, even if the agent steals the money. What is the principal's liability for acts of not agents but subagents? In essence, a subagent is an agent of the agent. The general rule is that when an agent hires a subagent, both the principal and the agent is bound to the third party by acts of the subagent. An exception to that is known as ministerial acts. Ministerial acts are acts that do not usually involve judgment or discretion. In these cases, the principal is not bound by acts of the subagents, but rather the agent is. As we know, the agent represents his or her principal in contracts. So for the next few slides, we're going to talk about contracts. Generally, the agreement binds only the principal and the third party, and the agent, who is simply a middle person, is not liable. However, it's going to depend on how the principal is disclosed to the third party by the agent. There are three types of principals. Again, there are three types of principals. The first one is a disclosed principal. The second one is an unidentified or partially disclosed principal. And the third one is an undisclosed principal. The difference between these three types of principals will be based on either the existence and or the identity of the principal to the third party. A disclosed principal, the first one, a disclosed principal is a principal whose both existence and identity are known to the third party. Let me give you an example. If I'm a principal and I have my agent go down to the Mercedes dealership in Valencia and I want that agent to buy a certain Mercedes for me, if that agent goes down to the Mercedes dealership and says to the salesperson at the dealership, "Hi, my name is so and so. I'm an agent acting on behalf of my principal, David Adams." Here, the salesperson knows that the existence of an agency relationship as well as the identity of the principal. Thus, I am a disclosed principal to the third party. The second type of principal was the unidentified or partially disclosed principal. This is a principal whose existence is known to the third party, but whose identity is not known to the third party. Let's use the same example. Now the agent goes to the Mercedes dealership and says to the salesperson, "Hi, I'm here as an agent to buy a car on behalf of my principal, period." Now the salesperson knows of the existence of a principal but doesn't know my identity, doesn't know my name is David Adams. The third type of principal is known as an undisclosed principal. An undisclosed principal is a principal whose both existence and identity are not known to the third party. Let's use the same example. Here, my agent goes down to the Mercedes dealership in Valencia and says to the salesperson, "Hi, my name is so-and-so and I'm here to buy a Mercedes, period." The salesperson has no idea of my existence, and if he or she doesn't know that I exist, there's no way that the salesperson can know my identity. So to recap, a disclosed principal is a principal whose both existence and identity is known to the third party. An unidentified or partially disclosed principal is a principal whose existence is known to the third party, but whose identity is not known to the third party. Finally, an undisclosed principal is a principal whose existence and identity are both not known to the third party. Why is it important to have a distinction between these types of principals? Because the agent really is a middle person, and he or she really doesn't want to be liable for a contract. Here are the situations where an agent is personally liable for the contract. Number one, the agent acts without authorization. So if I'm a principal and I tell my agent to go down to Valencia to buy a car and instead goes down to Valencia and buys a clock, that's an unauthorized act. The agent would be liable because he or she acted without authorization. The second way an agent is personally liable on contract is if the principal is incompetent or doesn't exist. The third way that an agent is personally liable for a contract is if the agent agrees to assume liability. If the agent is dumb enough to assume liability, then he or she should be personally liable. The fourth way is if the principal is undisclosed. Remember, that's a principal whose both existence and identity is not known to the third party. The agent is liable because the third party assumes the agent is contracting on his or her behalf. So if something goes wrong, the third party is going to sue the agent. The principal is still required to repay the agent for any losses that A suffered. So in this case, what would happen is, remember, you go down to the dealership in Valencia, and the agent says, "Here, my name is so-and-so and I'm here to buy a Mercedes." If something goes wrong with the transaction, the Mercedes dealership doesn't even know I exist, so it can't know my identity, so the Mercedes dealership would sue the agent to recover. Then the agent would go to the principal and sue the principal to recover any losses. The fifth way that an agent is personally liable for under a contract is if the principal is partially disclosed. Remember, that's an unidentified principal. That's a principal whose identity is known or whose existence is known to the third party, but whose identity is not. Remember, that's when I, as a principal, tell my agent to go down to the Mercedes dealership, and here the agent says, "Hi, my name is so-and-so, and I'm here to purchase a Mercedes on behalf of my principal." Period. Remember, the dealership knows that the agent's acting on behalf of the principal but doesn't know my identity. So if something goes wrong, the dealership's going to sue the agent, and then in turn the agent would sue the principal. Remember, our first type of principal was a disclosed principal. Here the agent's off the hook. Remember, a disclosed principal was a principal whose both existence and identity is known to the third party. So if something went wrong, the dealership knows my existence and my identity and can sue me directly. Thus, the agent is off the hook. The last two slides, we're going to look at liability not for contracts, but rather for torts on this slide and the next slide, and crimes on the second slide. Let's talk about torts first. Agents are personally liable for torts and crimes when acting for the principal under the doctrine of respondeat superior, or let the master answer. Vicarious liability, otherwise known as indirect legal responsibility, is based on the notion of respondeat superior. Thus, the principal is responsible without regard to whether the principal was actually at fault, so long as his or her agent was acting within the quote-unquote scope of the agency when the tort occurred. So factors to see if the tort occurred in the scope of the agency are the four questions that you can see on this slide. Remember, respondeat superior is based on vicarious liability or indirect legal responsibility. Let's look at direct liability now for tort. Direct liability is where the principal is liable because of its own tort. So direct liability can come under two different outcomes. One, if the principal personally directed the conduct of the agent that caused the injury. Second is known as negligent hiring. That's where the principal fails to do certain acts when hiring the agent, such as fails to do a background check, or failure to do proper training, or failure to supervise. Finally, let's look at criminal liability of the principal. Agents do not have to commit a crime even if directed by the principal, because that's a violation of any agency agreement. So the principal will be liable if he or she directed, participated, or approved of the crime of the criminal act. This concludes our lecture on Chapter 24, Liability of Principals as well as Agents to Third Parties, otherwise known as External Agency.